This is Bloomberg Law with June Grasso from Bloomberg Radio.
The extremely tight presidential race is fueling visions of a sequel to Bush v. Gore, the controversial Supreme Court decision in 2000 that put George W. Bush in the White House over Vice President Al Gore. Judges around the country are grappling with the more than 190 election-related lawsuits filed since 2023, and litigants are already positioning their cases to seek quick Supreme Court help if needed. With the six-justice conservative majority, which includes 3 justices appointed by former President Donald Trump, many are concerned that politics will play a role in any decision. A new Pew Research poll shows that a majority of voters do not have confidence that the Supreme Court will be politically neutral in resolving potential legal challenges around the 2024 presidential election. Despite that, most election law experts say the legal realities and the math make it unlikely there'll be a sequel to Bush v. Gore. Here to explain why is Bloomberg Supreme Court reporter Greg Stohr. You know, what people have in mind when they think about this election season in the Supreme Court, they think about Bush v. Gore. So remind us about Bush v. Gore and why it might or might not be relevant this year.
Sure. So Bush v. Gore came in the context of an election that was so close between George W. Bush and Al Gore that it was decided by a single state and less than 1,000 votes. So after that state was certified for Bush, Al Gore used a provision in Florida law that lets the loser of a very close election contest the results. And that is essentially what led to a ruling by the Florida Supreme Court ordering the recounts of some ballots in the state. And when the Supreme Court overturned that ruling on December 12th of 2020, that had the effect of sealing that state and therefore the election for George W. Bush.
Most election law experts that I've talked to, and apparently that you've talked to, don't think that we'll have another Bush v. Gore this election season. Tell us why briefly, and then we will go into detail.
Okay. Well, part of it is the math that I alluded to there, which is in order for there to be a Bush v. Gore type case, you have to have a legal issue that will resolve enough to shift or decide the election. Looking at, say, 2020, Donald Trump would have needed to flip at least 3 states to erase Joe Biden's victory, and the Supreme Court showed no interest in getting involved. So that's one thing. And the other thing, which we can get into more, is that for a variety of reasons, the Supreme Court and other actors in the system, state courts, have sort of narrowed the universe of possible cases and issues that might get to the Supreme Court in a way that would decide the election.
Yeah, let's talk about how they, as you put it in your story, narrow the pathways, so to speak, to reach the Supreme Court. So first we have, and we talked about this so much last year and even before last year, the independent state legislature theory that the justices rejected.
Yeah, so this is a Supreme Court case known as Moore versus Harper, and essentially what one side of that case was arguing is that state Supreme Courts have basically no role in setting the election rules, that state Supreme Courts cannot interpret what the state legislature has done in a way that affects how the election is going to be conducted. And the Supreme Court rejected that theory. It would have, given the Supreme Court itself a very broad authority to say, hey, state Supreme Court, you have no jurisdiction here. We're going to enforce the will of the legislature. There's still, though, a kind of narrower argument here, which is that if the U.S. Supreme Court said, if a state court is interpreting a state law in such a way that it departs from sort of the ordinary bounds of judicial review, that the Supreme Court can step in, even though it doesn't usually reverse a state court on a matter of state law, and say, state Supreme Court, you've gone so far beyond what you're supposed to do that you've actually violated the U.S. Constitution and the provisions that govern presidential and congressional elections.
And how have the justices limited the authority of federal judges in election cases?
So this is something that has become known as the Purcell principle. The Supreme Court has said in a variety of contexts that a federal judge can't come in at the last minute and say some state law is unconstitutional and block it just before an election. And the concern there is that they'll be creating too much confusion and chaos right before the election. Now, at least as it's been applied so far, this is only something that applies to federal judges. It doesn't apply to, say, what a state Supreme Court does. But it does apply to the Supreme Court itself, at least to the extent that the Supreme Court has articulated it. And so what that potentially means is that even if the Supreme Court sees something, tomorrow that it thinks the state is doing that's unconstitutional, that the Supreme Court won't jump in and tell the state you've got to change what you're doing, because that might just create confusion. So, for example, there's something that is pending right now where RFK Jr. is trying to get his name off the ballot in a couple states, in Wisconsin and Michigan. And the Supreme Court might well say in that case, we're not going to come in and tell a state where voting has already begun, suddenly you have to change who's on the ballot, even if we think that RFK Jr. could be on the ballot there.
So people have pointed to the fact that in 2020 there were, some 60-odd cases that Trump or his followers brought, and that the Supreme Court didn't intervene in any case. But has the Supreme Court gotten more brazen about interfering? I mean, looking at one of the most controversial decisions of the term that allowed Trump to avoid a federal prosecution on election interference grounds. I mean, most people thought that the court would never go that far.
No question, that was a very bold decision, and the court decided more than it needed to in that case. The question is whether that translates into the election context. And, for the reasons I sort of laid out there, and, the law professors and others I talked to for the story that I wrote, the overall sense is that in terms of actually managing the election, the Supreme Court would very much like to get out of it. And you see this in a variety of contexts. For example, in the context of gerrymandering, the Supreme Court has said we don't want to be involved in deciding whether districts are too political. Now, that decision got a lot of criticism, but it is a sign of the Supreme Court, and John Roberts in particular, really not wanting to be more deeply in this sort of stuff than they absolutely have to.
So you also point out that state courts are also taking some issues off the table. So let's turn to the swing state of Georgia, which has had a lot of litigation about elections this year. So tell us what happened in Georgia recently.
Yeah, so Georgia, a state election board run by Republicans, put in place a couple rules, and they included one that said you have to have a hand counting of ballots in every county, and another one that said that county officials have to conduct an inquiry into the correctness of the election results before actually certifying them. And a lower court judge, a state judge in Georgia, struck that down, and then the Georgia Supreme Court also rejected the challenge to that. And that essentially meant that that rule, which could have been a very significant deal because it could have significantly slowed down the election results in Georgia, but that rule is now off the table. And that was one that some folks were very, very worried about. So it's by no means everything that state courts are taking off the table, but there are a lot of issues both very recently and over the past months and years that state courts have tried to get resolved in a way that doesn't prevent an issue at a moment of crisis for the U.S. Supreme Court.
There are two cases before the court now where they could get involved or not. Virginia is asking the justices to revive the state's purge of voter rolls in these final days before the election.
Yeah, Virginia, of course, worth mentioning, not a swing state that we're expecting to help decide who actually wins. It's a state that is almost certainly going for Kamala Harris. But in Virginia, under the order of the governor there, the state was purging its voter rolls of people the state says believed to be non-citizens who shouldn't be on the voting rolls. And that was halted by a federal court. And the state is now asking the Supreme Court to let that purge continue. The estimates that are out there are that it's roughly 1,600 people whose voter registrations are canceled. We should know potentially in the next day or two whether the Supreme Court is going to let that purge go forward.
So now we have, I want to say Pennsylvania is a critical swing state. It's a swing state and it's critical. So there are a couple of cases sort of ongoing in Pennsylvania, but tell us about the one that the Republican Party is asking the Supreme Court to take.
Yeah, you're right. There's a lot of litigation in Pennsylvania, and we may well see more litigation at the Supreme Court before this is all said and done. But the one that's there now has to do with people who voted by mail. And in Pennsylvania, what you're supposed to do is you're supposed to put your ballot inside a so-called secrecy envelope. Then you put it inside the bigger envelope that you're going to mail. And when officials receive it, they can't process it yet. But what they can do is they can weigh it, and they can determine whether you may have forgotten to put the secrecy envelope in there. And so what officials in Pennsylvania did is, for those people who did not seemingly include their secrecy envelope, they let them know and let those people cast a provisional ballot that had the effect of sort of superseding the one that they had mailed that was going to be invalid because it didn't include the secrecy envelope. And so the question is whether those provisional ballots are going to count. And we don't know the exact number of ballots that are at issue here. I've seen one estimate that it could be anywhere between, this is by law professor Rick Pildes, anywhere between 400 and 4,000. But the Republican Party is arguing that under state law, those ballots can't be counted, that election officials did not have the authority to say we're going to essentially declare the mail-in ballot void and let you cast the provisional ballot. So anyway, that is now at the Supreme Court. The Republicans are asking them to put a lower court ruling on hold that allowed the provisional ballots to be counted. One possibility here, because this is sort of similar to a dispute we had 4 years ago, is that the Supreme Court, at least for now, will say, okay, what you need to do is to segregate those provisional ballots, the ones that may or may not count, and we'll figure out later whether they actually count. And so it might be a way for the court to kick the can down the road just a little bit so that they don't actually have to decide this issue unless it actually matters in the outcome.
Coming up, I'll continue this conversation with Bloomberg Supreme Court reporter Greg Stohr. We'll talk more about Pennsylvania. A federal judge in that state made a ruling just today on overseas ballots. You're listening to Bloomberg. The election is less than a week away, and we've seen a flurry of last-minute decisions from state and federal courts across the country in cases challenging voting rules. In the pivotal swing state of Pennsylvania, just today, a federal judge threw out a challenge brought by 6 of the state's Republican lawmakers over overseas voting. The Republicans wanted to make state election officials institute new checks to confirm the eligibility and identity of soldiers, sailors, and others who vote from overseas. But federal Judge Christopher Connor said he agreed with the defendants, Secretary of State Al Schmidt and one of his top deputies, who argued there were no grounds to sue and that the case was launched too late and too close to Election Day. I've been talking to Bloomberg Supreme Court reporter Greg Stohr. There are so many election cases going on in Pennsylvania, it's hard to keep track of them. But another fight is over whether mail-in ballots will count if the voter didn't put the right date on the envelope. I believe that the latest decision was that mail-in ballots without the correct date will not be counted. Is that decision also at the Supreme Court? I'm confused as to what stage that's at.
That is not yet at the Supreme Court. It is still percolating. I don't know precisely the state of play in that one, but it is an issue that has been very controversial, and it may well end up at the Supreme Court, particularly if Pennsylvania is so close that those ballots might matter.
I'm thinking about Bush v. Gore again, Greg. If one state is so close and there are these issues, I feel like the Supreme Court might get involved in this. All the experts say no, but I have this nagging feeling, Greg. Tell us, because a lot of people probably don't know about this Electoral Count Reform Act. Tell us about that.
Yes, so this is the law that Congress passed in 2022, largely in response to what happened in 2020 and the efforts by Donald Trump to get Mike Pence, who as vice president was presiding over the counting of electoral votes, to get him to take steps to essentially override the will of the voters. And the Electoral Count Reform Act, which was, basically a compromise between the parties, in this time of closely divided government, it's hard to get anything through. But among other things, this law clarified that the vice president has only a ceremonial role in the counting of electoral votes, that the vice president can actually refuse to certify the result. It does some other things as well. It sets a firm deadline for states to submit their certified results to Congress. It had previously been a little bit fuzzy. It was sort of a soft deadline. And it also raises the threshold for lawmakers who want to object to the results from some state. And if you recall, in 2020, it took only one member of Congress to object to the results. And now you'd have to have 20% in each chamber. So that law is, mostly designed to avoid people trying to overturn the results during the counting of electoral votes, or to eliminate the kind of chaos and controversy that happened 4 years ago. It may also create along the way some legal issues that are a little hard to foresee now, some things that maybe aren't clear, haven't been tested in the courts. That often happens with new laws. But it might also, in the hopes of people who supported it, to sort of reduce the opportunity for controversies.
As we were discussing, there are lawsuits in a lot of the swing states. Pennsylvania's ballot rules, Georgia's certification requirements, and these lawsuits are sort of coming up the ladder. And after the election, could they become issues that the Supreme Court will deal with?
Yeah, they could. There are, cases out there where both sides have sort of tested out their arguments. They've been accepted or rejected by lower courts, and there's at least the possibility that would give one side or the other sort of a quick avenue to the Supreme Court. So I mentioned, we started off talking about Bush v. Gore and how that particular case didn't actually get to the Supreme Court until just a few days before the December 12th deadline. And now that sort of thing could happen again, because states do have these procedures where you can challenge the results if you're a loser by a very close margin. But there's also the possibility that, a pre-existing case could get to the Supreme Court and affect what happens before a state certifies its results.
Every time I talk to you, I mention that confidence in the Supreme Court is at an all-time low, sinking. And a new Pew Research Center poll shows that only 20% of voters are highly confident the Supreme Court would be politically neutral in any election case. Might that affect their desire to get involved in an election case?
I think it almost certainly is affecting their desire. I think it's pretty clear that they would prefer not deciding this case, not doing something, not having another Bush v. Gore. Whether that's actually enough to make the difference is another question. Ultimately, so many things the Supreme Court does are matters of discretion. That, even Bush v. Gore was a case where the court didn't actually have to take it. But what we've heard from members of the majority in the aftermath was they felt like it was their role at this moment of real chaos and confusion and controversy that had gone on for weeks to provide some certainty. And, at this stage, it's impossible to say for sure whether this desire not to get involved will be overridden by their sense, which may or may not be the same as your sense or my sense, but their sense that they are needed to come in and create a final decision that, they would hope would be accepted by the country.
Do you think that we'll hear this week about whether they're going to take the Virginia and Pennsylvania cases?
I think we will almost certainly hear something about those cases. I would not use the word take, because these are probably just going to be orders that say, either Virginia can purge these names from the voting list or they can't, and it may be, an order that says these folks can or cannot cast those provisional ballots, or, as I said, requiring officials to segregate the battles so they can decide it later. I think we will get something from them. It is not likely to be, because nobody is asking for it at this point, one of these cases where they schedule arguments and, actually issue a big ruling on the merits.
No time for that. Election day's coming. Thanks so much, Greg.
My pleasure.
We will see how this all plays out shortly. That's Bloomberg Supreme Court reporter Greg Stohr. Coming up next on the Bloomberg Law Show, we're going to be talking about the court's shift to analyzing cases based on history and tradition. It's an approach that even has judges going to libraries to check on historical data. You might say it's a new, old way of looking at constitutional questions. The Supreme Court's super-conservative majority is now relying more and more on history and tradition to analyze issues, whether it's abortion rights, gun rights, or free speech rights. And it has judges and lawyers alike saying it's making their jobs more difficult. Joining me is Lydia Wheeler, Bloomberg Law Supreme Court reporter, who's written about this. Lydia, explain the history and tradition, test, analysis, focus, whatever you might call it, of the conservative Supreme Court justices.
So the court's conservative 6-3 majority has been turning to history and tradition to settle basically constitutional questions. So we saw them cite centuries-old treaties when the court overturned abortion rights. They pointed to English history dating back to the late 1600s when they allowed more guns to be carried in public. And they looked at state practices from the founding era of our country when they rejected a free speech challenge just last term to trademark restrictions. So, they're constantly taking what they call an originalist theory to decide these cases.
Can you pinpoint when this started? Because the late Justice Antonin Scalia, conservative icon, promoted this originalist theory. But I remember one interview where he didn't even think it was going to take off the way it has. He said something like, well, this will be something law students will be talking about. When did it become so important that even the liberal justices are having to use it?
So we really saw it in a gun rights case known as United States versus Rahimi. That was a decision last term, considering the legality of a law that banned firearms for those subject to a domestic violence restraining order. But even prior to Rahimi, we really saw it in the Bruin case. That was another gun rights law, that was asking about where you can carry guns in public or not. And so the court really relied on history and tradition to determine these constitutional questions. But it's not just in gun rights cases that we're seeing it now. It's really carrying over into all sorts of other disputes, mostly related to constitutional questions.
And do the justices even agree on exactly what it is? Because in Rahimi, which you mentioned, there were 5 concurrences, and it was an 8-1 decision. And each justice seemed to want to explain their idea of what it is.
Yeah, we are seeing a lot of separate writings in cases. We saw specifically in Rahimi where each justice is kind of trying to figure it out and explain their own approach to this. So there is a lot of disagreement on the court. And we're hearing from lower court judges that this is causing confusion for them and that this history and tradition kind of analysis has actually made their job a lot harder.
And you write that some lower court judges are going to the library to do their own historical research?
Yeah, absolutely. So we heard from Judge Pamela Harris. She is an Obama appointee on the Virginia-based Fourth Circuit Court of Appeals. And she said that, judges have to go to the library now to do their own historical research. And, I heard her speak at a law conference in September, and she was really lamenting the fact that judges now have to go back in time, she said, and become historians. And short of that, she said, that she's finding it very, very challenging to do her job. And that this has actually raised some practical questions about how she should approach her decisions.
It must be really time-consuming.
Yeah, absolutely. So that's something even conservative judges are saying. I heard from David Strauss. He's a Trump appointee on the Missouri-based Eighth Circuit Court. He said it's not, more challenging to do this kind of work, but he is acknowledging that it takes longer, and that to go and do this kind of research, it's taking him longer to write his opinions. And, Pamela Harris, who was on this panel with Judge Strauss, she said that, it's raising questions for her about if she wants to join a colleague's opinion, because it's a 3-judge panel that is hearing this appeal. And if her colleague who's writing the majority did their own historical research, she was asking, does that mean she has to kind of go back and also do her own historical research to fact check them? So those are the kind of practical questions, even judges are saying, what do we do here?
Is anybody saying, yes, this is terrific. Let's go back to the 16 and 1700s when society and technology and everything else was so different. Let's go back to find our opinion today. Does anyone really love this test?
It seems like some members of the court do like it. And they view the Constitution as it should be interpreted as the way it was written when it was adopted in the 1700s. And so we are seeing time and time again they're returning to this. And we are seeing that this is something that law schools kind of are behind the curve on and are just now starting to think, okay, maybe we need to start offering some classes and training, our students on kind of this originalist theory.
What does this mean as far as the kinds of clerks that judges are looking for nowadays?
Yeah, so it really seems like that any clerk who has this experience in this historical research kind of has a leg up when they're applying for clerkships. So I chatted with Isha Anand. She's at Stanford's Supreme Court Litigation Clinic, and she's also on the law school's clerkship committee. And she said that she's seen students kind of get an advantage if they have this experience or a background in historical research. She said that judges are definitely interested and perk up when they hear that that experience is, on that student's resume when they're hiring for future clerks, because it is taking them a lot of time to do their own historical research. So, they are looking potentially at clerks who already have experience doing this to make the process maybe go a little smoother.
Are any of these judges concerned that this is just going to become overwhelming? I mean, they're supposed to be interpreting the law, not interpreting history according to what we were taught in law school.
So that was, Judge Harris on the Fourth Circuit. She had a lot of concerns about this and about if she's doing it right. And because that's one thing that even, attorneys that argue before the court regularly say is difficult. I chatted with one lawyer who said that this analysis is tough because there can be so much material to comb through. He said that you sometimes might have to go back, and look at state and federal laws that are hundreds of years old and go back in time that far. So, yeah, it is something that judges are saying are difficult. My colleague, Suzanne Moniak, reported that some law schools are actually getting pressured to teach this originalist theory. Like I mentioned before, it's this theory that the Constitution should be interpreted as it was understood at the time that it was adopted in 1788. And one conservative appeals court judge, actually Amol Thapar, on the Ohio-based Sixth Circuit, he urged donors in a recent speech at a heritage event, he said to donors that you should withhold your support for law schools until they actually start hiring ideologically diverse teachers and start teaching this originalist theory, because he said that judges need clerks and attorneys who are equipped with this understanding of this theory of law. And he said that judges are just overworked and lack the time to kind of pore over these historical texts.
Well, I remember that Justice Scalia and Justice Stephen Breyer used to appear together to talk about the Constitution. And it was Justice Scalia advancing the originalist theory and Justice Breyer advancing the living Constitution theory. You don't hear much talk about the living Constitution anymore on the court. I think even Justice Kagan said at one point, we're all originalists now.
Yeah, I think that is a byproduct of the fact that we have a 6-3 conservative majority on the court. And so, the liberal wing is at a disadvantage here if they want to, or if they have that view of the Constitution. I think to cede ground or maybe find common ground, they have to kind of look at this historical analysis themselves and try to find the path forward, working within that framework.
I was looking at the Supreme Court calendar for next month, and I have to say I wasn't very excited with the cases there besides election issues that may be coming up, which I spoke to Greg Stohr about, I mean, how would you characterize this term from what we've seen so far?
Yeah, so attorneys we talked to, at the start of the Supreme Court term really said that this is going to be lacking in the number of blockbusters that the court is hearing right off the bat. And actually a lot of these cases for the first couple months are going to be what he described as kind of the meat and potatoes type cases that we typically see. They're digging into complicated statutory questions over laws. And so a little bit more drier of the subject areas. But, the court is still taking action on its emergency docket. Just yesterday, we saw that the Supreme Court agreed to stop a ruling from the Fifth Circuit from taking effect that found the enforcement provisions of a federal anti-doping horse racing law unconstitutional. So the court, stayed that decision from the Fifth Circuit, which really came down against a federal law known as the Horse Racing Integrity and Safety Act. And the justices put that decision on hold while they, consider whether to hear the dispute over, in this case. And, that's a law that actually empowers a private organization known as the Horse Racing Integrity and Safety Authority to set and enforce rules for the industry. And the Fifth Circuit said, well, those enforcement provisions violate what's called the private non-delegation doctrine, which is a legal principle that says that a private entity may wield government power only if it functions subordinately to the agency with authority and surveillance over it. So they said that this is a law, these enforcement provisions are unconstitutional, and so the Supreme Court has already stepped in to say, oh, wait, we're going to put that on hold while we consider whether to hear this case or not.
The Fifth Circuit being the most conservative circuit in the country that often sort of pushes the envelope of the law with novel theories. And the Supreme Court, last term in particular, had to, I'll use the term, put them in place by reversing a lot of their decisions. Are you keeping track of how many Fifth Circuit cases the Supreme Court is hearing this term? I haven't counted them up yet.
My colleague has a spreadsheet, and we she was just looking at them the other day, and it is quite a few actually. We haven't done the comparison yet to past terms, but it looks like there are a lot of Fifth Circuit cases already popping up. So that's going to be something to watch for sure.
Okay, thanks so much, Lydia. That's Bloomberg Law Supreme Court reporter Lydia Wheeler. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.